Good morning, everyone. Welcome you all to the TAI webinar. My name is Bunsita Samritpon, and I'm honored to serve you as an MC for today's session. As a legal officer at the Thai Arbitration Institute Office of the Judici, or the TAI, it's my pleasure to guide you through our discussion. Our focus today centers around the theme of investor-state dispute resolution mechanism. I would like to highlight that we are broadcasting this event live through Zoom and Facebook Live. So if you think this event might be beneficial for anyone and they haven't joined yet, please feel free to share them with the link. Today's event is being organized and conducted by the Thai Arbitration Institute Office of the Judici, and it will start at 9:30 and conclude at 11 a.m. Should you have any questions, and feel free to send them via direct message through the discussion, and our speakers will answer them at the end of the webinar. Now allow me to introduce our moderator. She's an impressive academic background, having graduated with a Bachelor of Laws from Thammasat University, followed by Master of Law in Intellectual Property Law from University of Edinburgh, and Master of Law in International Trade Law with Merit from Durham University. She is a litigator with over a decade of experience in cross-border litigation and international arbitration. Her strong track record includes handling disputes for Thai state-owned entities, as well as acting on Thai insurance disputes. She sits on panel of arbitrators of several international arbitration institutes and also been appointed as an arbitrator in several domestic and international arbitration cases. Currently, she holds the position of partner at Arbor Law Group. Ladies and gentlemen, please welcome our moderator, Ms. Dutsadi Phanit.
Thank you, Ta. Okay. Good morning, everyone. We warmly welcome you to TAI webinar focusing on the topic of investor-state dispute resolution mechanism. With the steady rise of foreign investment in Thailand, it's become increasingly crucial to establish efficient dispute resolution method. Investor-state dispute settlement assume to play an important role in maintaining fairness and fostering positive relations between investor and host country. It also boosts investor confidence, encourage significant projects, and ensure compliance with the international rules. However, navigating investor-state dispute settlement involves grappling with complex legal concepts and procedure. So today, our webinar will offer an comprehensive exploration of investor-state dispute resolution mechanism, provide insight and example from ICSID, UNCITRAL rule, and other alternative approach for resolving dispute between the investors and the host country. We are privileged to welcome our distinguished speaker, Professor Vishai Ariyanantaka, advisor from the Thai Arbitration Institute, Mr. Jonathan Sheffield, legal counsel from ICSID, who will share their expertise on these mechanisms. This webinar will last for 90 minutes, divided into 3 parts. First, an introductory presentation of ICSID. Second part, an overview of alternative investor-state dispute resolution mechanism outside ICSID. And third, the last part, a panel discussion covering other interesting aspects. Before we begin with our first section of ICSID, please allow me to introduce our honored speaker. Start with Professor Vishai Ariyanantaka. He graduated a Bachelor of Law with honor from Chulalongkorn University, Barrister at Law from Thai Bar Association. He furthered his study with a Thai government scholarship, leading to a Bachelor of Law with honor University of Wales, Master of Law University of London, and Barrister at Law from Grey Inn. He was a Secretary General to the President of the Supreme Court, a Chief Judge of the Central Labor Court, Executive Director of the Thai Arbitration Institute, Lecturer of the Tort Law at Thai Bar Association. And he was a Senior Judge of the Central Intellectual Property and International Trade Court. Currently, he is an advisor to the Thai Arbitration Institute. Our next speaker is Mr. Jonathan Sheffield. Mr. Jonathan holds master degree in International Economic Law from Paris Panthéon Assets, and another master degree from University of Connecticut. He earned a PhD in International Law from European University Institute in Florence. He is also admitted to the Paris Bar. His work experience, Mr. Jonathan is now serving as legal counsel at ICIT. He is on a case management team. Prior to join ICIT, he worked as an attorney at law with White & Case in Paris and as a consultant for the France Ministry of Economic Affairs. Now, let's start with our first section, where Mr. Jonathan will address various topics, including a brief presentation of ICIT, the advantage of ICIT system, new rule and innovation, and the outcome and information of ICIT Award. The floor is yours, Jonathan.
Thank you very much, Chitsadi. It's a real pleasure to be here today and to have the opportunity to discuss ICSID with you, with Professor Vishai, and with the TAI. I'm going to jump right in. I wish I realized that many of the participants, if not all of the participants right now, I know that it is broadcasted live and we cannot see like all the people like looking at this from their computer, but I see that all of the participants are Thai. I wish I could do the presentation in Thai. I've just moved in Thailand a few months ago. Give me another few months and I will be able to at least say a few words in Thai again to say how grateful I am to be here. I'm going to try to share my slide. I hope it's going to work. So if you bear with me 1 second, here we go. No, it doesn't work like this, right? Try again. Yeah, hey, here we go. So thank you very much again. I will speak for hopefully less than 30 minutes. I really want to save time at the end for the Q&A. But of course, like feel free to interrupt me during the presentation if anything I say is unclear or if you require more details on one of the topics that I present. I'm going to speak very quickly about ICSID, giving a few words about the institution. I know that most of the things that I will say are very basic, and so I already, I know that many people are experts in the audience, so I hope that I'm not going to be too repetitive with what the people know in the audience. And then I will say a few words on ICSID proceedings. We could speak about ICSID proceedings for hours, so I'm not going to do that. I'm going to focus only on a few specific aspects, including enforcement, because I know it's an interesting and important issue here in Thailand. And then I will say a few words on the amendments, the 2022 amendments process that ICSID went through and that resulted in the adoption of new innovative rules, that apply to all types of ICSID proceedings, arbitration, conciliation, mediation, and other types of proceedings. So here we go. Let's say a few words about ICSID first and its mandate. So ICSID is an international organization that has been established in 1966, and it's one of the 5 institutions of the World Bank Group, with the IBRD, which is the main organ of the World Bank, and other institutions, including IDA, IFC, MIGA. All of them are. Thailand is a member of for all of these other institutions, and we will talk about it in a minute. Thailand has signed the ICSID Convention, but has not ratified it. So Thailand is not per se a member of the ICSID Convention. The purpose of the ICSID Convention and ICSID more generally is to provide for an impartial facility to resolve investment disputes which are disputes between investors on one side and states on the other. And by doing that, we know that ICSID contributes to the depolitization of such investment disputes, and we know we have stats on this that it contributes as well to increase cross-border investments around the world. ICSID is the leading institution for ISDS, and this is because it administers approximately 70% of existing and public investments arbitration and known public investment arbitration proceedings. And the main function of the ICSID Secretariat, which is the body for which I work, is to administer international investment disputes. So like my job on the day-to-day is to provide assistance with tribunals or with dispute settlement bodies for the management of investment disputes. We also provide support in dispute resolution proceedings. So ICSID not only assists existing tribunals, but may also assist institutions that are interested in investment disputes. We provide trainings, technical, and in doing that, enhance the knowledge in investment law and investment arbitration. It's typically what I am doing today, presenting ICSID and investment arbitration. And again, in doing that, we believe that we contribute to the development of international investment law and international dispute settlements. This is a map of ICSID membership as of January 2024. So you can see that there are 158 states, the one in blue on the map, that are members to the ICSID Convention. And there are 7 states that have signed the ICSID Convention but not ratified it. And you can see them on the screens, and Thailand is part of them. They are the states in yellow on the map. And then a few others that have not joined ICSID at all. Those are, a snapshot of the membership benefits, what the state gets when they become members to the ICSID Convention. First of all, I mean, it's important to remind that, because the membership, you join ICSID at no cost. It's free to become a member of ICSID. There are no annual contributions that are asked from the states when they are ICSID member. The benefits are numerous. First of all, being a member of ICSID shows that you are in favor of global investment flows, and it complements domestic economic policies which aim to promote foreign direct investments, protect investors in foreign states. So that's one main aspect. Second, ICSID members, they have a role in a leadership role in participating in any discussions on ISDS at the global level. And the main example is the amendments. I will talk about it in a few minutes. We reform ICSID's rules and regulations, and that reform process was a collaborative process with all the members of the ICSID organization and ICSID Convention, and all the members had the possibility to intervene, participate in actively this process. And so by being members to the ICSID Convention, you participate in the developments, the reform, the perfection of the ICSID, of the international investments legal system. You also, each members also have the possibility to appoint arbitrators on the ICSID list of potential arbitrators and conciliators. So that's another benefit. And then, of course, you can benefit from the ICSID Convention and the ICSID system, and I will explain that in a minute. What makes ICSID special, and what makes it this main institution for the the resolution of investment disputes. First of all, it's a totally impartial and delocalized institution and system. You know, it's an international institution. It's based in Washington, D.C., but the convention makes sure that any ICSID proceedings is delocalized. It's not connected to a local domestic system, and in that sense, it's perfectly impartial and neutral. We have a very cost-effective fee structure, and we could talk about it for a long time. I didn't bring the stats with me on these issues, but they are available online, and ICSID disputes are believed to be one of the cheapest, way of dealing with investment disputes. It's the only institution that can administer ISDS under the three main set of procedural rules available for investment disputes: the ICSID convention, for sure, the ICSID additional facility mechanism. I will discuss that in the next slides, and then the UNCITRAL. We have ICSID disputes in which the UNCITRAL procedural rules are applicable, and that's the only institution for which that is possible. ICSID has a full-time secretariat with experts and lawyers like me, that have experience in dealing with investment disputes and that can assist parties and tribunals, dispute settlement bodies, mediators in the dealing with such disputes. ICSID has been referred to as the ISDS Court Secretariat under recent free trade agreements. Everyone knows that there are discussions to create a possible multilateral investment dispute settlement mechanism, and today, the EU, which is very much in favor of that and try to push for that, has itself selected ICSID in its existing agreements as the secretariat for such dispute settlement mechanism. So it shows that the ICSID system is trusted amongst the players of the international investments dispute settlement field. And then, of course, ICSID has its main facilities in Washington, D.C., which is where the World Bank is located, but we have agreements with, we have also another facilities, hearing facilities in Paris. It's closed right now for renovation, but hopefully it will open again in the next few months. And in addition to that, we have a partnership agreements with many arbitral institutions around the world, and which allows ICSID to organize hearings when it's easier and more practical for the parties and the tribunals or dispute settlement bodies elsewhere. And if it's easier for the parties to meet on the African continent, we have agreements with Kenya, for instance, and the parties can use the Kenya Center for International Arbitration. So that's another special feature of ICSID. Just a few words on this. Again, we could talk a lot about getting into the practicalities and the theory of the ICSID legal systems, and I don't want to do that. I want to save time for the questions at the end. But just a few words on this. ICSID is, as I said, independent institution, but it's also the conventions also creates independent and centralized legal system. The convention works in itself. You don't need to add other rules to make an ICSID dispute settlements mechanism work. It's a complete a set of rules that is combined with ICSID other instruments, and all these instruments, when they work together, they work by themselves without the needs of adding other external norms or rules. I talked about the ICSID convention. I really want to say a word about the ICSID additional facility rules and regulations. So the ICSID additional facility, I have the screen captures that you see on screen are screen captures of the books. I don't know if you can see them. Yes, they are here. The ICSID additional facility, it's the yellow one here, it's a body of rules that mirror the rules that are contained in the convention with a few distinctions, a few differences, but it's the same general system and principles, and it's available for disputes in which only one party is member to the ICSID convention. So for instance, if you had an investor that comes from a country that is not party to the convention, but wants to act against a state that is party to the ICSID convention, then he could use the ICSID additional facility rules for this type of disputes. So that's a very convenient tool. And I know that at least 6 of the 43 Thai BITs refer to this ICSID additional facility rules in addition to ICSID. When can, I think it's a very important point. Again, we could discuss about jurisdiction of the center of ICSID for hires. I want to say just a few words on this. When can a case be brought to ICSID? And this is a very complicated discussion, of course, with many legal ramifications. But there are 2 main. We can summarize this debate or this discussion with 2 main points. The first one, of course, is the relevant jurisdictional requirements must be fulfilled. And these jurisdictional requirements are contained in the ICSID instruments that you are using to bring your case to ICSID. And so first of all, you have to have an investment dispute, that is a dispute that relates to an investment. And this dispute has to be between an investor and a state or a state agency, but it's between a private entity and a public entity. And then there are additional requirements depending on which type of method that you would like to use. So for instance, if you're using ICSID arbitration, then you would look in Article 25 of the ICSID that relates to jurisdiction of the center for such arbitrations. And then there are other requirements, including nationality. So that this is where we see that for an ICSID arbitration, you have to have an investor that comes from a state that is member to the ICSID against a state that is itself member to ICSID. So that's a nationality requirement. But for mediations, for instance, we don't have these nationality requirements. And so ICSID mediation is open to any companies, any states, even if they are not member to the ICSID convention. So I think it's an important point. So that's the first condition, fulfillment of the relevant jurisdictional requirements. Second conditions, you have to have consent. You have to have an ICSID dispute settlement clause that is contained in the legal instruments that you are using as the basis of your dispute. So if the legal instruments that is being used as the basis of your dispute is a contract, you have to have an ICSID clause in the contract. If it's a BIT that is being signed between the state where the investment comes from and the state against which the investor acts, then you have to have an ICSID clause in this BIT, bilateral investment treaty. But those are the 2 main conditions. Again, if you have questions on this, I'm happy to address them. Looking at this, like what type of instruments are used to initiate ICSID disputes. So the main category remains bilateral investment treaties, but we can see if you look at this graph historically, we can see that it is a little bit changing. The next category is our investment contracts. And so there are 15% of the disputes initiated against ICSID are based on contracts between investors and states or state entities. And then you have other types of instruments, so investment laws, for instance, multilateral instruments such as the Energy Charter Treaty or free trade agreements. The ASEAN is not represented here specifically, but it's part of the other treaties category, and it's an instrument that can be used to initiate an ICSID dispute. Now, I mean, I think the best is to give an example. And I thought about a recent case. It's not public, unfortunately, so I cannot talk a lot about this case, but I thought it was interesting because it brings to play regional actors. And it's a case between a Malaysian company, KLS Energy, and Sri Lanka. And that case was initiated based on the BIT between Malaysia and Sri Lanka that refers to ICSID, and the investments was about a project for the construction of a wind and solar energy power plants, and whether and then the authorizations that were given to the investor for the constructions of this project or for the launch of this project at some point were withdrew from the Sri Lanka's government, and a dispute arose after that. And the dispute again was brought based on the BIT, and the proceedings unfold. The case is still is about to be concluded. So again, I cannot talk a little bit about too much about this case, but I think it's an interesting example of a Malaysian investor in the renewable energy sector acting against the state that allegedly changed the authorizations needed to initiate such a renewable energy project. This is a nice picture of the hearing facilities that we have in Washington, D.C. You can look. I was very happy to have the opportunity to visit the TAI a few weeks ago. I think they really look the same, and this is like we have screens, we have tables, space for experts, space for arbitrators. It's a very nice hearing facility. It's state-of-the-art, technology for remote connections, hybrid connections, things like that. And that's an actual hearing that was going on a few years ago. I don't have too much time to discuss, like the specifics of like proceedings, arbitral proceedings, conciliation proceedings, but I want to say a few words about the ends of arbitral proceedings. What happens when we arrive at the end of a proceedings? And of course, an award is issued by the arbitral tribunal, and pursuant to the relevant rules within the convention, the ICSID convention. This arbitral award terminates the proceedings and is a final and binding on both parties, the state and the investor. The type of reparations that are usually given in ICSID awards are those known and found in public international law. So there are these classic international legal reparations. And so, for instance, I put here like an example, a screen capture of an award that is not that recent, but it's interesting because it combines different types of reparation. It's an award against a French investor and Moldova. And here you can see in that screen capture that the tribunal combined different types of reparation, including restitution, which is the first type of reparation and known under public international law, monetary compensation, which is the main reparation type that is being used in ICSID arbitration statistically, and then of course costs based on the result of the dispute. What can happen once an ICSID award is issued? So there are a few remedies that are available against this award. And you remember I told you that the ICSID is an independent and complete system. So all these remedies are actually contained in the ICSID legal instruments, including in the ICSID convention. And so if you realize that are errors, like arithmetical errors, for instance, or if there is a point that needs to be clarified in the awards, the convention gives you the possibility to act before the original tribunal to make the necessary corrections, and this mechanism is available under the ICSID convention. And then you have another mechanism that is called annulments, and it's available under Article 52 of the ICSID convention. It is not an appeal of the award, but allows what we call an ad hoc committee, so another body, to review the awards in case there is an allegation of a breach of 5 grounds that are contained in the convention. They are listed here on screen at Article 52 of the convention. You can look them up online. And these 5 grounds, of course, it's a different mechanism than resisting the enforcement of an international arbitral award, a non-ICSID international arbitral award. But if you look at the grounds, you would certainly see some similarities, in the formulations and in the principles that would be applied when you decide whether an award can be annulled, or outside the ICSID context, whether an award can be enforced or not. So that's a very important feature of the exceed mechanism. Sorry, what about like a few statistics on the outcomes? You know, like because like a lot is being said, you know, on how exceed is being used and you know who wins, who lose cases. And here I think it's there. I have two slides to talk about this. The first one here is you know, it shows the general outcomes of all existing exceed arbitration proceedings. So it focuses on arbitration specifically, either based on the exceed convention or based on the exceed additional facility. And you can see that actually 36% of such disputes are terminated before the end of the proceeding. So it means, I mean, there are different situations in which a proceeding can be terminated, but usually it means that the parties found an amicable solution. They settled throughout the proceeding, and I think it's an important point. You know, it's in more than 1/3 of the time, the parties they find an amicable solution after the initiation of the arbitral proceedings. What happened when the case actually goes to the end? When the case actually goes to the end, and that's another graph here that focuses only on cases that have resulted in a final decision. And here you see the dark blue with 47%. 47% are the case in which the tribunal decided to uphold the claims, the investor's claims, in full or in parts. So it you could qualify this as a win for the investor. So the investor win in 47% of the case. And then you have the rest, which is divided in 3 categories. The claims are dismissed on the merits. The tribunal rejects jurisdiction. Or the tribunal decide that the claims are manifestly without merits. So, I mean, this slide I think is very interesting because it shows like the great balance, of the outcomes, and whoever would say that states always win or investors always win. I mean, this is not correct based on actual statistics. Enforcement, I know it's an important issue. And we might have questions about this. I mean, again, exceed being independent legal system, the rules with respect to enforcement are contained in the exceed convention, and you're all aware of Article 54 of the convention that provides that an exceed award can be enforced within the territory of all the members, the members to the exceed convention. So it means that if you have an award against a state A, you don't necessarily need to go before the courts of the state A to enforce the award. You can go, if B or C are also members to the exceed convention, you can go before the courts of B and C to have your award enforced. That's one important point. The second important point is that an award under Article 54 of the convention is supposed to be treated as if it was a decision of final instance of the domestic courts where you seek enforcement. So there is no possibility to review the award before domestic courts. And that's an important point as well. But again, you saw from what I said before that there are remedies available within the exceed system, and it's only when the award is final, when there are no decisions of annulment, if annulment is sought, then that the award can then be enforced. Yeah, and again, if I questions about this, I'm happy to discuss these issues in more details. A few words, and I told you I would speak about like innovations, and I will finish with that. Exceed went through the process started even before I joined Exceed. It started in I think it was in 2016, we first started to talk about the necessity to reform Exceed rules and regulations. And it was a long process, again, because we involved all the members. We received comments from the civil society. Exceed really tried to involve all the players of the international investments legal community and arbitration community more generally. And that resulted in the adoption in July 2022 of new rules. So the convention did not change, but the rules that are applicable through the convention or the ICSID additional facility rules were reformed, were amended. And the main objectives of these amendments, and that's what you can see within the new rules, was to it was multiple objectives, but among these objectives, we ICSID wanted to offer a broader range of options for investment disputes. And so we have not only modified and amended and modernized arbitration and conciliation, which were mechanisms that existed originally under the convention. We have added new. We have created rules for new rules for other types of dispute settlement mechanism, including mediation, international mediation, and what we call fact findings, which is a system that allows parties to a potential disputes to bring in experts and identify, facts relevant, like information, and hopefully in the objective of avoiding a dispute. So that's a very innovative feature that we created under these new rules. Another objective was to, achieve a better efficiency, in the settlement of disputes, and so we have changed, like in practice, it resulted in changing deadlines, making sure that the process would be, more straightforward, streamlined procedures. We have new options for emergency arbitrations and things like that, which allow a better and more efficient way of settling disputes. We did that through maintaining the procedural balance. It's one of the fundamental aspects of ICSID, like keep the procedural balance between the parties, and we managed to reform the rules while, keeping this balance. We have increased transparency. I will say a few words on this specifically. We have strengthened provisions to avoid conflict of interest between arbitrators and the parties. And we have introduced new provisions to decrease ICSID's environmental footprints. So those are the new set of rules, that are available since 2022. So you have the convention and the new arbitration rules. This is the blue book on the screen. You have and that's so that the convention, it's for arbitration and conciliation under the ICSID convention, and you have the ICSID additional facility rules. And again, this is for what I told you before, when a party is not member to the convention. And again, here that reproduces rules for arbitration and conciliation, again available even if one party is not member to the ICSID convention. That's the yellow book. And then you have the green book, which are mediation, the new mediation rules. And again, this is available even if the parties are not member to the ICSID convention. And the red book, which are the fact-finding rules, which I referred to before. And you have links on the side that will, of course, make the slides available, and you can, click and explore these new rules. One word, and I will finish with that on transparency. I know it's a very important issue here in Thailand. The new rules have created a very top-of-the-art transparency system for ICSID proceedings. And one might say that it's in some aspects it's more robust than other transparency rules that exist and that can be applied in investment disputes, and for instance the UNCITRAL investments UNCITRAL transparency rules. These new ICSID rules allows for the publication not only of awards but of decisions and documents that are issued throughout the proceedings. And for instance, I am myself working on a case in which the parties accepted that, and all the decisions, even the small procedural decisions that are issued by the tribunal throughout the proceedings are being made available on the ICSID website after, of course, the party had the possibility to comment on possible reductions or confidential information on these decisions. But it shows that how extensive this new system is. Not only the awards can become public, but also the decisions that are issued before. We have clarified the rules for accessing hearings. If the parties consent to that, it becomes a possibility, and we make sure that logistically it's possible. We have experience in this respect. And again, we have clarified the rules for the participation of non-disputing parties, what we call like amicus curiae. The rules have been modernized in this respect. And to give you a practical examples, and this is what resulted from the new rules, it's a new practice in ICSID arbitrations, is that when a tribunal is constituted, we invite the tribunals and the parties to discuss a specific procedural order addressing transparency based on the new rules. And so we really, the parties are supposed to discuss the general organization of the proceedings, but in addition to that, we invite them to discuss specifically transparency and to agree on the transparency regime that they want to apply in their arbitration. And it shows like in practice specifically, and here is a draft of the template that we send to tribunals and parties to organize this discussion. And it shows in practice how transparency is being implemented. And I will finish with that. I don't know if I managed to stay under the 30 minutes. It looks like so. Thank you again. If you have questions, I'm very happy to address them. Thanks.
Thank you very much, Mr. Jonathan, for sharing the insight from ICSID and also like your experience. As Thailand is quite new to ICSID, we signed but not ratified yet. So I think this is going to be like a benefit to everybody who listen to this webinar. And also like from your very interesting presentation, there are some questions from the audience, which we will discuss later after Professor Vichai sections. Okay. Now, I would like to invite Professor Vichai to discuss on the investor-state dispute resolution outside ICSID. So I will have 4 main questions to asking Professor Vichai. The first one is about rethinking investor-state dispute resolution mechanism. The second one is Thailand involving landscape in administrative contract dispute settlement. Third question is about international civil and commercial litigation. And the last one is about innovative step in other alternative dispute resolution rule, for example, like UNCITRAL, also like the Hague Convention on the Choice of Cause Agreement, and also maybe discuss about Singapore Mediation Convention a little bit. Okay, so Professor Vichai, I would like to start the first question with you. So let's begin with our first topic. Okay, currently Thailand, we have 2 notable investor-state dispute cases. The first one is the case of Waterbound versus the Kingdom of Thailand, which involved the allegation of breach of the Germany-Thailand BIT, and is being handled under UNCITRAL rules. The second case is about Kingsgate Consolidated versus the Kingdom of Thailand, which alleged a breach of Australian-Thai Free Trade Agreement, and is also under UNCITRAL rule. Thailand, we quite familiar with the UNCITRAL rule. The first, my first question is, I would like to argue like, I would like to hear from your perspective on what can be learned from these cases, and also the second question, maybe you can provide a comparative analysis involving UNCITRAL, mediation, court procedure, and also like Jonathan, you can please feel free to elaborate on the ICSID aspect as well.
So thank you, Madam Chair. I enjoyed and benefit a great deal from Jonathan's presentation, and it's great for us to revisit ICSID Convention. As Jonathan mentioned earlier, we, Thailand, has signed the ICSID Convention many years ago, but we sort of hesitated to accede to the convention, maybe or maybe not because of an Article 54. The ICSID award shall be treated in the enforcing state as if it were the final judgment of that country. Now, I do not have the privilege like Jonathan to represent an institution, although this webinar is organized under the auspices of Thai Arbitration Institute, of which I am an advisor. But by the way, Thai Arbitration Institute has been in existence for over 30 years. It may be one of the oldest arbitration institute in Asia, but I in no way or in any way represent TAI in my views or what I'm going to express today. It's only represent or reflect my if I could say experience in legal practice all my life so far, but mostly on the bench and teaching law. So from this point of view, I like to look at ICSID and the prospect of Thailand joining ICSID in the light of our experience on Waterbow and Kingsgate. Now, we have joined another convention of World Bank, that is MICA, Multilateral Investment Guarantee Agency. It acts somewhat like an insurance thing. If you are an investor or a prospective investor in Thailand, you insure it with MICA, this organization of the World Bank, just like you would go to an insurer to insure against political risks in the investing state. You go invest in Thailand. This is a huge project, a mega project that you cannot afford to miss. But you might view that there may be or might be certain non-commercial risks, i.e. political risks from the government of the day, and then you insure it, and then you claim in case the risk has occurred. You claim against MICA, and MICA pay the compensation. MICA subrogated the claim and bring the investing country to the host country to ICSID, and then you have an ICSID award, and by that way Thailand must adhere to the ICSID convention, subject to the condition of annulment or whatever. But at the end of the day, we sort of have to enforce ICSID convention through the Multilateral Investment Guarantee Agency convention. So there's nothing new to that. The way around this for Thailand to enter into MICA without having an implementation act, save for the acceptance, the immunity and privilege of this institution, is that there's a cabinet resolution that if there's an award from MICA, then the state agency concerned will oblige accordingly. Now, whether we join or not to join ICSID, perhaps the question should be why not? You have now almost or around 150 countries in the world who are members of ICSID. You have 170 countries in the world who joined New York Convention on the recognition and enforcement of foreign arbitral awards. So why Thailand joined New York Convention but not ICSID Convention? It's interesting. This is some personal perspective of mine that we are the very first, some of the very first countries who joined New York Convention. We joined back in 1959. At that time, Singapore is still a fishing village or a part of Malaya. But we joined, and the second country in ASEAN that joined were Cambodia, because back then Cambodia and Thailand were going to involve in an international dispute at the ICJ, International Court of Justice, over the sovereignty over the Temple of Priyavihira, Temple of Pravihan. So both countries were very enthusiastic to join international community and commit to international obligation under the New York Convention. So Kun Dusadi mentioned about Kingsgate and MICA. Kingsgate, the Australian enterprise, Australian company who were granted a concession of a gold mining at Pijit. This is a concession contract, and Australia were protected under the free trade agreement, and there Kingsgate, which is a Australian enterprise, after granted the concession, ensure the political risks or non-commercial risks, not with MICA, but with Zurich Insurance Company. And then after Kingsgate claimed that there were political risks and there were damaged by that political incidents. Well, this is still sub judice, but then Kingsgate claimed from the insurer, and they have a certain sum of compensation from the insurer, and reputedly they funded arbitration under UNCITRAL in Singapore through this fund. So it's very interesting in how this worked. And Waterbow is another very interesting investor state dispute resolution, of which we mean Thailand invested a lot in our reputation, in expenses involving this case. The award was a mere 29 million euro plus, but the expenses in all the arbitration, litigation ensue were enormous. We had litigation after the award at the Thai Administrative Court for setting aside. The Supreme Administrative Court dismissed the government of Thailand motion for setting aside. Then the Thai government went to Swiss court for setting aside. Waterbow went on to enforce the award at the hearing at the Southern District of New York. And the affirmation hearing there took place in New York, and then the Court of Appeal for the Second Circuit. Yeah, the American court affirmed the award. Then obviously you have the interesting incident in the German court concerning enforcement as well. So having these phenomenon that one will have to involve internationally in any case. This is something that the legal profession in Thailand must gear towards providing legal service not only to domestic dispute but to international dispute. And the court likewise, well, we have the court which has been established after Thailand acceded to the World Trade Organization back in around 1994. We have established the Thai Intellectual Property and International Trade Court. We have established the Thai Arbitration Institute prior to that. So the legal profession in Thailand must be prepared for litigation and arbitration, and now negotiation and mediation in these very complex, very international, very cross-cultural conflict. Now, law school as well. I can tell you that now two of the best law schools in Thailand in alphabetical order, Chulalongkorn and Thammasat, have law courses, both LLB and LLM, teaching in English in order to be serving international legal community like Kun Dusadi. So we need to upgrade these in order not to fear going to litigation at Intellectual Property International Trade Court or TAI and having the proceedings in English, or go to High Court in Singapore, in Hong Kong, London, wherever. Very recently, a Thai investor, Thai Lao Lignite, yeah, had a dispute with Lao Democratic Republic. People, well, the Lao Democratic Republic of Laos, and that concerning the power plant and mining. The case, the dispute went to applying antitrust rule. They went to KL for arbitration, and there's a setting aside case in Kuala Lumpur Court, High Court, and the Court of Appeal, and then there were enforcing the award in New York, in London, in Paris. So this is not new to only the Thai public sector, but the Thai private sector who invest abroad as well. Recently, there's a decision of the High Court of Justice in London involving around almost 20 individuals and companies who mostly are Thai. The cause of action arose in Thai, applicable law, Thai law, and then this is sub judice because maybe is still pending appeal to the Court of Appeal in England, but the case involving millions, multi-billions of baht. So why this is basically a Thai connection, but people the plaintiff choose to almost like a forum shopping to go to the High Court in London. So you see, the enforcement of foreign judgment or the enforcement of foreign arbitral award is not new anymore. It's very prevalent. So I think, why not we consider, well, ICSID, because of the enforcing the award in Thai court as if it were the Thai judgment that is a step further than the New York Convention. Yes. We may also think of the Hague Convention on a choice of court agreement 2005 and the Judgment Convention of The Hague 2019 for the reciprocal enforcement of foreign judgment in civil and commercial matters. Because one of the consideration is that Thai investors are investing all over the world at this moment. Some Thai enterprises are global, are multinational in its activities. So Thai basically have assets not only in Thailand but maybe in France. They people have chateau in France and have a great apartment in London or in New York or wherever. So Thai have assets abroad, and let's say English court or American court, they have this multilateral agreement to enforce their judgment elsewhere. For example, an English judgment, you can enforce the English judgment in all the Commonwealth countries, in all the Hague and Lugano Convention countries. So you see, there's no boundaries anymore. And if we were to have this international setting of arbitration or international trade court in the real sense, we need to consider that seriously. It's not about independence of the court. It's not about sovereignty. It's about interdependent. It's about cooperation. It's about the effectiveness and efficiency of dispute resolution, whereby you can enforce your judgment where it matters. And likewise, instead of hinder the obliging other people judgment, enforce them in your country, you promote your legal industry and to deal with these, and you export these judgments and awards to enforce elsewhere in the world. That's the philosophy that law school are starting to do. At this time, the law schools attract some of the brightest students to come to law. At my time, the brightest students always go to medical school, go to engineering school, but this time some of the brightest, like all the industrialized countries, some of them choose law schools. So law school must cater for them, not just for the domestic service, but international service. So that's the message that I would like to give, and maybe we should have some more interactive discussion. Sorry, Madam Chair, that I took too much time.
Yeah, I think Professor Vichai have many interesting points, especially like nowadays Thailand we involve in many international transactions, and also like we have a lot of international investment. So we should adhere to like a more international system, right? Okay. I think now we have a lot of questions from the audience, and also like I have some question to ask you as well. Maybe we can start our last section. So we will discuss on the question from our that we prepare, and also like from the audience. So I found some interesting question from the audience, and this is also my question that we prepare as well about like the question is if the investor state arbitration is bound to be transparent, will such circumstance disrupt the core principle of arbitration proceeding? How will it cope with the existing idea that arbitration need to be confidential? I think it's about like how could we balance between transparency and confidentiality, which is the core of arbitration.
Let me go first. You see, the idea of arbitration is a secret meeting, a secret proceedings that is contrary to the court proceeding, is maybe have a new horizon of thinking, particularly the investor state dispute resolution. State always claim public interest. And what is the most fundamental public interest is that the people in that country must have access what the government or government agency did in that transaction, in that project. So everything must be transparent, i.e. public will have to access to it. All the documents concerning the dispute will be published. Arbitration, ancitral, exit is open now, will open to public. And then people with non-party can have a say in the Latin words is amicus curiae, friend of the court. So particularly, for example, if we look at the mining concession or the project involving environmental issue or health issue, let me cite an arbitration between the giant Philip Morris versus a small country, Uruguay. Yeah, the cigarettes and health. So the Uruguay government have so many NGO and presenting the arbitration with the briefs, their opinion on that. Now, law faculties, professors of law may have some great idea on this public interest involving a dispute. The only way that this law professor can appear in court is through being an expert witness. But through this new mechanism, this professor of law can initiate the amicus brief. So the case will be more open, the public will have more access. The government could not hide. I mean, any government could not hide in this process. And this is why it's called transparency.
If I can
Yeah.
add just a few words, I mean, I couldn't agree more with what Professor Vishai has said. And you know, I'm looking at the questions, and it's based, you know, on the premise that that's the end of the question, you know, like that the existing idea that arbitration needs to be confidential. And I have myself a question, like, why, you know, why do we think that arbitration needs to be confidential? Like, where this need come from? And if you look at the ICSID convention, there is no presumption for confidentiality. Exceeds arbitration because, as Professor Vishai said, involves states, is not presumed to be confidential. So it's, I think it's a very an important aspect, you know, like in answering this question is arbitration, you know, when it involves private parties, we can understand why there is a need, because they have private interests, you know, sometimes it involves, you know, commercial discussions, commercial interest that needs to remain confidential. But when you involve a state, the things are different, and so that's, I think, a very important aspect. A second thing that I wanted to mention very briefly is that you said, you know, that a balance need to be found, and this balance can be found in, like, with proper, you know, rules that are well understood, that can be well interpreted by the parties, by the arbitrators. And that's what you know, ICSID, the new ICSID arbitration rules on transparency bring. You know, they bring a good balance between like the needs for transparency in disputes that involve states, and also the needs for efficiency of proceedings, you know, making sure that if you involve transparency, it will not slow down the arbitration process. It's not going to impair the arbitration process. And again, I invite you, and there are many rules in this respect. We cannot discuss them all, but I really invite you to look at them and see how they strike a balance. And the final thing is that all these rules, at least in the ICSID system, you know, they're based on parties' agreement. You will never have a tribunal that is going to decide, you know, without consulting with the parties on issues such as transparency. And so the parties will always have the possibility to comment on whether, you know, transparency shall be kept and what it means, like whether an award will be published, you know, when, you know, and the rules allow for the parties to be consulted and to give their views on what it means, you know, to have or not to have transparency in disputes. And we agree that there are some disputes, even when they involve states, at least for sometimes, maybe it's better to keep them confidential, because it's going to ease, you know, the discussions between the parties, for instance, or for other reasons. And so it's a possibility that the parties themselves want to keep things confidential, at least for some time. And the rules allow that, because the parties will always be consulted.
Okay, thank you very much. Okay, so maybe we can move on to the next questions. This one maybe to you, Jonathan. The question is like, how that ICSID deal with case between public enterprise and private enterprise? I mean, maybe it's about when the investor, foreign investor, put ICSID in the contact between investor and state enterprise. Yeah.
Yeah, sure. So it's very, very interesting question, very important question. And you know, I said at the beginning of my presentations that ICSID is about disputes between private parties and public parties, including states. There is a possibility to bring disputes against state agencies. That's the expression that is being used in the convention, and that is possible when the state itself did thing that shows that the agency has given its consent. You know, so they cannot be ICSID without consent. So to answer the question how to deal with such case, if the private enterprise can be considered as a state agency based on different legal criteria or different legal requirements, if it can be considered as a state agency, and if it has consented to ICSID arbitration, because the state said so, then it can be brought before ICSID. So there is a possibility, but there are requirements that need to be satisfied, and these requirements are contained. I mean, the main requirements are contained in the Article 25.1 and 4 of the ICSID Convention, and I invite the person who asked the question to look at these articles and of course not to hesitate to follow up with me by emails if they have further questions on these aspects.
Okay, thank you very much. For next question is for both of you. This question, the audience asks about how to earn trust from public enterprise if the case often result in favor private enterprise. Okay, this is the question from the audience. But to me, as I working with many government entity, the government always claim that when they join arbitration case, they always lose, you know. So this question might be about like the proportion of the result of the winning case between the private and the government. Is it true that normally the tribunal will have the award in favor of the government, or maybe like in favor the private company, something like that?
Let's look at the hypothesis of this assumption. If you look at the consumer cases in the court, obviously we set on the presumption that we can trust the Thai court. Now, can you say that when a financial institution bring a case to the court, the great percentage, the cases brought by financial institutions or the people who are financing and high purchase will probably win. This is not one will have to look at this hypothesis. Let me tell you a funny story, which is true. When we established the TAI back 30 years ago, the best PR person for the neutrality, impartiality, and independence of TAI in state versus investor conflict, administrative contract cases, were the PM of the day. There was a Thai Prime Minister. Now, he is famously having a rest on the 14th floor somewhere. He said, why arbitration? The government always lost. You know, this is also based on the assumption that when you go to an arbitration or international arbitration, the arbitrator is always someone who is from international trade background. And even in ancestral version, when you are having a place of arbitration somewhere else, you always have a Western European person and a Northern American law professor or an Australian professor. Then these are people, are lawyers who are more closer to the understanding of the investors or investment. Whereas when you go to the court, and that's why there's always a tendency now of talking about multilateral investment court or go to the court itself. When a judge, when you go to a court, you have a more, shall we say, public-minded, the one who is more sensitive towards public interests, and this is very much the establishment of Thai Administrative Court back in 2542. That was a rough calculation is back in 1999. This is very much a French concept, of which Jonathan should be very proud of. We established the administrative court by the influence of French law, French philosophy, and the Conseil d'État. No, sorry. Conseil d'État. I thought I said coup d'etat. Sorry, it is Conseil d'État. Now, you see, the administrative court, it distinguishes itself from the Court of Justice. When there is a government contract in common law parlance, in the public law parlance, is contrat administratif or administrative court. And then the judges and the public law will take into interest the public interest into the public policy, where we'll look into the, for example, once in Thailand, several decades ago, we granted concession to logging. Yeah, and we found that logging was detrimental to the environment. So all the logging concession were terminated. So in accordance with the public interest, cutting down the trees is detrimental. So this is something that the government should do. Then the government compensate the private investors, or the one who get the concession grant, what they have invested, and how much the loss of expected profit should be granted. This is something that must be clear, and this is something that you will find this line of argument more from lawyers who are more acquainted with public law. In this country, when you have this private versus public enterprise, and then one needs to know that this will be governed by public law and administrative court. So the traffic, the work which would have gone to arbitration on administrative contracts, now go to the administrative court. It's almost like the French system, where the domestic administrative contracts will go to the court rather than arbitration. So this may explain more or less.
Do you have anything to add on, Jonathan?
No, just one word. I refer back to my presentation. On the outcomes of exit disputes. It's like when you look at the statistics, it shows that the results, the outcomes of the disputes are very, very balanced, and it's not true that the states always win or that the private parties always win. It's very much balanced. So refer back to my slides, and again, happy to elaborate on this in writings if needed.
I recently see the statistics from Ansitol as well. The balance is quite well as well. You can search more on Google. Yeah. I saw some interesting question to you, Jonathan. Can ICSID administer case under Ansitol or other rules?
Yes, and the answer is very easy. It's yes. ICSID can be used to administer disputes that are brought under other types of arbitration rules, not only ICSID arbitration rules. And to give you an idea, I think at the moment we have 16 cases before ICSID that are based on UNCINTRAL, and 6 cases that are based on other types of arbitration rules, so not ICSID and not UCITS, all other types. So in total, it's 22 cases to date that are based on other types of rules, including UNCITRAL.
Okay, so I think since we're running out of time, I will argue for one last question about diversity. I think for investment arbitration, it's quite a complex procedure and legal ground. And from what I see from many awards, and also like from many council, most of the person who participate are male, and mostly come from the Western. So I would like you to update about the current situation about diversity in investment arbitration, especially the concern about gender, nationality that represent in tribunal arbitral. Yeah.
I can start if that's okay with you, Professor Vishai. I mean, ICSID is very aware of these issues, and you know it is very open about these issues. We publish information regularly on the ICSID website about the appointments that are being made before tribunals, and so we know that there is an issue to be addressed, you know, with respect to gender diversity and other type of diversity, for instance, geographical diversity, and so we are aware of that. And when you look at the trends, you know, it's slowly moving. It's moving, like one might say, too slowly, but it's moving in the right direction. And there are more appointments of female arbitrators throughout the years. And that's obviously a very good thing. It's going in the right direction. Same for geographical diversity. You know, when you look at you know, historically was arbitrators were mostly coming from Western Europe or North America, and now when you look at the appointments that are made in the recent years, and specifically appointments that are made when ICSID is involved, there are much more diversity. And I'm sure you will be happy to know that after like Western and America, the third you know, geographic region that is being represented in appointments of arbitrators is the Southeast Asian region. So we have many arbitrators appointed in ICSID disputes, especially when the ICSID is involved in the appointment process, coming from the Southeast Asian region. So yeah, it's definitely something that we all need to work on. You know, appointments are made mainly by the parties, and so the parties need to be aware of that. And ICSID, you know, is publishes information to make sure that the parties are aware of these issues. And when the appointment is made by ICSID, we are also very careful, because then we are like directly involved. And when you look at the statistics, you know, like for everything I say is available. You know, you have documents available online. You can look at the ICSID statistic report, and it shows the appointments that are being made by ICSID when ICSID is involved, and it shows the evolution and the trends again that are going in the right direction.
And for Professor Vishai, can you update the diversity situation under TAI and the overview of Thailand arbitration?
Overview first.
Okay.
How can I neglect to stress to point out that the present Supreme Court, the president of the Supreme Court is a female. Yes, Chief Justice Anocha. And as far as arbitration is concerned, the executive director of Thai Arbitration Institute is none other than Judge Donaya, who got a first-class honors from Chulalongkorn University and LLM from Harvard. So, on the geographical diversity, I can back up Jonathan's view. The late Ambassador Professor Sompong Sucharitkull were a frequent arbitrator under ICSID in many cases, and now Singapore pride itself very much on international arbitration, and coming up, why not Thailand too? So the future is bright for inclusivity and in diversity, and you look at the Thai law schools. I don't know what happened to Thai because they are predominantly female, and some of the brightest, yeah, are female,
Okay.
including our chairman. Oh,
Uh,
sorry, chair. Yeah.
Yeah. Okay. Thank you very much. Okay, so I think now we're running out of time, so we have to close our webinar today. So thank you very much to Professor Vishai and Jonathan for sharing your experience and knowledge with us, and also thank you every audience who joined us today. So I think we have to close the webinar now. Okay, so I
Thank
have
you so
to
much,
say,
Vitaly.
Thank
say
you. Bye bye.
goodbye and have
Thank you
a
very
good
much.
day.
Thanks.
Thank
Bye.
you.
Thank
Bye
you.
bye. Thank you,
Bye-bye.
everybody. I
Bye-bye.
enjoyed it very much.
Bye bye.
Thank you.